Friends, my name is Nizamuddin Ahmed Siddiqui and I am an Assistant Professor of Law at West Bengal National University of Judicial Sciences, Kolkata. I will be taking this unit on right to property in India on behalf of the content writer Dr. K. Sita Manikayam, Assistant Professor, Dr. B. R. Ambedkar Law College, Andhra University. This unit aims to fulfill certain learning objectives which include an understanding of the evolution of the right to property in India. Number 2, an understanding of the constitutional perspective of the right to property in India. And number 3, an appreciation of the judicial approach behind the constitutional amendments to property rights in India. Now friends, with the above learning objectives in mind, let us first get a brief idea about the issues that we will be discussing in this unit. The economic thought weighs the Constitution as the founding of a welfare state and an economic structure embedded in the fulfillment of the individual, restricted and delimited always by the morals of the principles of the society in which the individual lives. It is therefore very fascinating to note down that right to property has induced a number of amendments to our Constitution and has also created the center from which some creditable and historic decisions emerged out of the Indian judiciary. The Indian Constitution does not identify the property right as a fundamental right. Now this is very interesting. In the year 1977, the 44th Amendment of the Indian Constitution removed the right to obtain, hold and arrange property as a fundamental right. However, in a different part of the Constitution, Article 300A was included to insist that no person shall be disadvantaged of his property save by authority of law. The effect therefore is that the right to property as a fundamental right has now been replaced as a statutory right by virtue of Article 300A to the Indian Constitution. Right to property has evolved over several years in India. Friends, we will now look at this evolution in the next couple of minutes. The Indian understanding and the origin of property and wealth have a very special historical basis when we compare it to that of Western countries. The fact that the current system of property, as we know, happens out of the peculiar developments in Europe in the 17th and 18th centuries. And therefore, the experiences around the world are not valid probably for Indian situation. A new economic part in which the answer is equally hard and significant is therefore as to the clarity of property rights. The idea of property as it has developed around centuries and has been embodied in our legal codes has become so great part of us that we have a propensity to obtain it for granted, and therefore we fail to identify the amount to which it constitutes and the rights of ownership of property and the benefit related to it that it confers around the social dimension of a living being. The right to property under the Indian Constitution has tried to move toward the question of how to switch property and the pressures relating to it by trying to stabilize this right with the right to compensation for its acquisition through an unlimited fundamental right to property, and then harmonizing the same with rational restrictions, adding together a further fundamental right to compensation in cases in which the properties are obtained by the state. Now, this has been exemplified by Article 19(1)(f), which is unbiased by Article 19(5) and the compensation article in Article 31. This was a motivating growth as it recognized the individual's right to property in opposition to the state. However, when the state realized that an absolute property and the wants of the people were not the similar, the legislature was afterward forced to make the said right to property subject to social welfare amid amendments to the Indian Constitution. Articles 31A, 31B and 31C are pointed to the change and counter the force of the state when it realizes that there are inherent troubles in yielding an obvious Western style absolute fundamental right to property, particularly under Article 31C, which for the first time brings out the social nature of property in India. The Constitution of India obtains its basis from the Government of India Act 1935 and the Universal Declaration of Human Rights 1948. Section 299 of the Government of India Act 1935 protected the right to property and enclosed protection against expropriation, lacking compensation, and against the acquisition of a non-public reason. Article 17 of the Universal Declaration of Human Rights also recognizes the right to private property, and India is a signatory to that declaration. The Constituent Assembly also examined the constitutions of diverse countries which guaranteed these basic rights to property. The Constituent Assembly of India, through constitutional precedents 1947, it is declared that the rights declared in the constitutions relate to equality before the law, freedom of speech, freedom of religion, freedom of assembly, freedom of association, security of person, and security of property. Within limits, these are all well recognized rights. When the draft Article 19(1)(f) and Article 31 came up for discussion clearly in the Constituent Assembly, it pointed out that the framers of our Constitution attached enough significance to property and they wanted to incorporate it in the chapter of fundamental rights. The provision regarding freedom of trade and intercourse, which was initially in the chapter of fundamental rights, was later detached from it and taken apart in Article 301 in view of the suggestions by some members of the Constituent Assembly. It is therefore important to note that similar suggestions in respect of the right to property were not accepted, and therefore it needs to be looked into. Friends, there is some misunderstanding about the scope of the right to property conferred under a constitution. A supposition by steady repetition has become a conviction in some minds that the right to property has been so ingrained in our constitution that it is not possible without amendment to enforce the directive principles which are mentioned in Part 4. An inquiry of the applicable provisions of the Indian Constitution as they stood on 26th of January 1950 will disperse this supposition. They are Articles 14, 19(1)(f), 19(5), 31, 32, 39(b) and (c), 226, 266 and 265. The substance of the said provisions may be in brief stated thus. Every citizen has the individual right to obtain, to hold and dispose of property. A duty is implicit in this right, namely that it should be so rationally exercised as not to get in the way with the like right of other citizens. The work out of it, therefore, should be rational and in accordance with the public interest. The directive principles of state policy lay down the fundamental principles of state policy for the governance of the country. And under the related principles for the governance of the country, under amended clause 2, the property of a citizen could be acquired or requisitioned by law, which offers compensation for the property so obtained or demanded, and moreover secures the amount of compensation or indicates the principles on which and the way in which the compensation is to be determined. It was additionally offered that no such law could be described in question in several courts on the view that the compensation provided by the law is not sufficient. This amendment made the state the concluding arbiter on the question of compensation. This amendment also awarded an arbitrary power to the state to fix at its carefulness the amount of compensation for the property obtained or requisitioned. The non-justifiability of compensation enabled the state to fix any compensation it decided, and the effect is by mistreatment of power to take away, which might result in the form of an acquisition. Article 31B and Schedule 9 commenced by the amendments was one more effort to suitable judicial power. It was a novelty set up in our constitution to no avail of in any other part of the democratic world. The legislature made void laws aberrant fundamental rights, and they were integrated in Schedule 9 and afterward on the list were extended from time to time. Article 31B confirmed that none of the acts or regulations precise in neither the 9th schedule nor any of the provisions thereof shall be deemed to be void because they are not in agreement with Part 3, despite any judgments, decree or order of any court or tribunal to the divergent. By additional amendment, the list was unmitigated. This amendment discloses a pessimistic approach to the rule of law and the philosophy essential to our constitution. The Supreme Court, by a variety of judgments, measured the said amendments and limited their scope within rational limits. The Supreme Court in Kochunni versus State of Madras in 1960 did not believe the request of the state that Article 31(1) after amendments gave an unobstructed power to the state to divest a person of his property. It held that Article 31(1) and 2 are different fundamental rights, and that the expression law in Article 31 shall be suitable law, and that it cannot be valid law if it amounts to a rational limit in the public interest within the meaning of Article 19(5). While this decision accepted to the state the power to divest a person of his property by law in an appropriate case, it was made subject to the condition that the said law should operate as a reasonable restriction in the public interest and be justifiable. The court construed the amended provision reasonably in such a way as to salvage to some extent the philosophy of the Constitution. But the Supreme Court in Srimati Sitabai Devi versus State of West Bengal held that Article 31 Clause 2, that is the provision connecting to the acquisition or requisition of land, was not subject to Article 19 Clause 5. It would have been logical if the expression law in Article 31 Clause 2 was given the same meaning as in Article 31 Clause 1. In that event, the law of acquisition or requisition should not only comply with the requirements of Article 31, Clause 2 and Clause 2A, but should also satisfy those of Article 19, Clause 5. That is to say, such a law should be for a public purpose, provide for compensation, and also make happy the double test of reasonable restriction and public interest provided by Article 19(5). The rationality of such a law should be tested from substantive and procedural standpoints. There may be a public purpose, but the compensation fixed may be so deceptive that it is unreasonable. The procedure arranged for acquisition may be so arbitrary and therefore irrational. There may be many other defects misbehaving the standard of reasonableness, both significant and procedural. But from a realistic standpoint, the current dichotomy between the two decisions, that is Koshini and Sitabai Devi, as I have already mentioned earlier, will not bring about any considerable hardship to the people. For a law of acquisition or requisition which rigorously complies with the ingredient of Clause 2 may normally also be reasonable restriction in the public interest. Substantive divergence from the principles of natural justice may also be hit by Article 14. Provision for an elusive compensation may be struck down on the ground that it does not comply with the obligation of Article 31, Clause 2 of the Constitution itself. The Supreme Court in P. Vajravelu Modaliar versus Special Deputy Collector in 1965 and Union of India versus Metal Corporation of India in 1967 cases measured Article 31, Clause 2 in the situation of compensation and held that if the compensation fixed was illusory or the principle arranged were immaterial to the worth of the property at or about the time of attainment, it could be said that the legislature had committed a fraud on par and therefore the law was bad. The consequence of the brief survey of the provisions of the Constitution and the case law, friends, thereon may now be stated in the form of the following proposals. Number 1. Each citizen has a fundamental right to obtain, hold, and arrange the property. Number 2. The state can build law impressive reasonable restrictions therein on the said right in the public interest. The said limits under certain situations may amount to the deficit of the said right. Number 3. Whether a limit compulsory by law on a fundamental right is rational and in public interest or not is a justifiable issue before the court of law. Number 4. The state can by law take away a person of his property if the said amount of deficiency amounts to a reasonable restriction in the public interest within the meaning of Article 19, Clause 5 of the Constitution. Number 5. The state can acquire or demand the property of a person for a public reason after paying compensation. Number 6. The sufficiency of the compensation is not justifiable. Number 7. If the compensation set by law is illusory or is different to the principles related to the fixation of compensation, it would be a fraud on par and therefore the legality of such a law becomes justifiable before the court of law. Number 8. The laws concerning agrarian reforms have been seen to include basically every agricultural land in a village, which cannot be questioned on the ground that these reforms have infringed fundamental rights. Friends, to conclude, we can say that the right to enjoy property with no illegal deprivation, not less than the right to speak or the right to travel, is in truth a personal right. Whether the property in question is a welfare check, a home, or a reserve account. In fact, a fundamental interdependence survives between the personal right to liberty and the personal right to property when it is visualized through a society in which each citizen should be the owner of a few properties, not only as a means of rations but also as a zone of safety from oppression and economic oppression, and that has to put the right above the vote of passing majority. The enacted Article 39 enjoined upon the state to break up the attentiveness of property in the hands of the few and its sharing with all. Though at the end of his detection of defensive property rights, even a person seems to have got mistaken by the so-called disagreement among directive principles and fundamental rights. Yielding absolute right to property and also having to sustain the holiness of a directive principle against attentiveness of wealth becomes almost an impossible thing to routinely achieve for any fair state which emerges and thrives on the foundation of the rule of law. Yielding absolute right to property and also having to uphold the sanctity of a directive principle against attentiveness of wealth becomes nearly not a possible thing to reasonably attain for any just state which emerges and thrives on the foundation of the rule of law. The Constitution of India had originally placed the rights to property in the correct viewpoint. Even as the individual right was safeguarded, the state was given plenty of power to legalize the exercise of it in the public interest through the rule of law. The amendments have, however, not only enormously increased the state's power, but also given a tyrannical point of view to the exercise of the said power. It is true, a state will become a just society where a right equilibrium will be maintained between the right to property and social justice. However, this has to be contextualized in Indian situation. Friends, with this we come to an end of this unit. I thank you all for listening with patience. Thank you.